Good afternoon, everyone. Hopefully you can all hear and see us clearly. Shake your heads or, I don't know, wave if you can't. Welcome to this East and West Sussex YRes seminar in conjunction with Westgate Chambers. We are coming to you live from Westgate Chambers today. I'm joined by Hannah, who is the chair of East Sussex YRes. Hannah is based at Family Law Partners in our Brighton office, and I am the chair of West Sussex YRes, and I'm based also at Family Law Partners in our Horsham office. So any YRes related questions for the region, please do get in touch with Hannah or I if you have anything you want to know about us or want to get involved. We'd love to hear from you. And I will hand over to Hannah to introduce our speakers for today.
So Polly and I are joined today by Scott Sharp and John Hatton from Westgate. Scott was called to the bar in 2016. He worked as a civil practitioner for a few years before joining Westgate in 2023. And John also did his pupillage here at Westgate before being called to the bar in 2019, and then joining Westgate as a tenant. And I think Scott is kicking us off today with a presentation on alienating behaviours, so very topical. If we can hold questions and we'll deal with them at the end, but do please put them in the chat box and we will address them when we finish.
Thank you very much. Good evening all. Lovely to see so many of you joining us for what hopefully will be a useful talk by John and I. I'm going to try and get the technology to work now and hopefully share a PowerPoint presentation with you all. So if you can all see that, that's going to be excellent. Of course, I'm going to be talking to you about what amounts to alienating behaviours, and it is, of course, something very new, or not very new, but very topical going through the courts at the moment. And I should probably start off by saying there is very much a lengthy draft guidance in circulation, which the majority of the information I've sort of pulled together has sort of focused. But what I've tried to do for everybody is also go over some of the complications with alienating behaviours. I'm sure many of you would have heard different forms of terminology used, and I know, I can say personally from my own experience, when one uses the wrong terminology in front of a judge, there's a certain backlash nowadays as well. But for everybody's benefit, I have created these terminologies. Now, these are my definitions, and I have pulled these out, one from the recent guidance, but two, you will see there, I still believe there's an appropriate phrase of parental alienation, which is, of course, the former title, and then alienating behaviours. You will see, my view, is the definition of parental alienation there. It is once the court has found that as a fact, once they have found one parent has acted in a particular way against the other parent, causing these issues with the child, that is what we can appropriately deem parental alienation. And I say that because a lot of the recent case law is still coming through the courts, and John will address you on one of the most pertinent ones later. But one of the more recent ones as well, literally published at the end of August, called REGB, uses both the phrasing alienating behaviours to discuss the allegations. And then, as I say, turns around 3 or 4 paragraphs later and says there hasn't been a finding of parental alienation. So there is some confusion still out there in terms of the use of terminology. But what I would certainly say is that when we're in court or paper-wise, alienating behaviours is the default to use. Parental alienation may be more behind closed doors to sort of address between colleagues. The question then is what is it? What is alienating behaviours? What amounts to parental alienation? As I say, what I've done for you here, and I'm not going to recite it all, is I've pulled out the previous definition of what CAF has defined as parental alienation. This being the unjustified resistance or hostility from a child towards one parent as a result of the psychological manipulation from the other parent. It's quite a nice, concise and simplified definition of what parental alienation would be. Of course, the new umbrella term, alienating behaviours, gives us a bit more depth as to actually what will we see on the ground? What do those behaviours look like? And of course, as you see there, Kafka's sort of own guidance gives this idea of a pattern of negative attitudes. There could be beliefs, there could be behaviours. It is far more than necessarily direct attitude, which I think is where the shift from parental alienation to the new alienating behaviours really comes from. What I would say, again, keeping along this trend though of why this area can be so difficult to track, is there are still alternative definitions available out there to practitioners. Now, I'm not going to take credit for it at all, but this definition here is a definition called From Practical Law. Fundamentally, this is how they have summarised alienating behaviours and parental alienation. And again, I'm not going to read it for you, but it's very clear this is an updated source. I mean, they make reference to, as I say, the case of Receive, which you will hear a lot about today, which was only published in, I think it was March this year, the final judgment to it. So it's very topical, very relevant. And as I say, I think it's just important that we all recognise there is still an influx of different language being used. Moving on, and again, I think this is the most important thing to recognise, is regardless of what we as practitioners call it, regardless of what language we might want to apply to it in a courtroom or outside of a courtroom, the impact that this has on children is the most pressing point. The fact that the emotional, the psychological, or sometimes the physical manipulation of one parent to cut another parent out of their life is really damaging on children, and it is something as practitioners we need to be alert to. And certainly, I know we all see cases coming through where parents make allegations, and it can be sometimes quite easy to become case hardened. But equally, I think it can be quite easy when something is brought to the forefront of people's minds to maybe jump to, well, this is parental alienation or alienating behaviours. So therefore, I've got to run a case for it. This here is again, I think I'm going to pause for a moment so everybody can have a read to it. But this is taken from Kafka's own guidance, and this is what a child has to say about the impact on them. As I say, I just wanted to have that pause because I think that's what we all need to really keep in our hearts and minds when these sorts of cases are coming through. It is actually, where do we start to look to recognise these behaviours? And now, as my view is, the first place to look is the child. How are they presenting? What are they saying? Why are they saying? The most recent guidance, or the draft guidance, and I'm going to talk about it a bit more, has created this list of parents' behaviours that we can look at as well. They're sort of being repeatedly or constantly criticising or belittling the other parent, unjustifiably limiting contact, undermining contact, so on and so forth. Again, what I would say is this is draft guidance, so it's likely to be expanded. And from my own views, I've added a couple more there, which I think, again, we as practitioners need to be alert to. Is a lot of what's in the list, from my view of this draft guidance, is proactive responses of one parent and deliberately sort of trying to show emotions or feelings to influence a child. But I think there are attitudes and behaviours which can also be subconsciously impactful, such as if a child wants to say, well, I'm really excited to see daddy, or mummy, vice versa, and then that parent has complete silence. That child is going to start to pick up on that. That child is going to start that they can't talk about the other parent they care for around the other parent because it's going to upset them. And again, we need to consider if at an early stage, if that's allowed to continue, is that going to amount to alienating behaviours? But as I say, there are some very clear-cut cases. And when I say my view is the first place to look is for the child, this slide here gives you a very clear example. If, of course, you have a child who 3-4 months ago was very loving, really happy to see one parent, and then 3-4 months later they're saying, no, I don't want anything to do with them, it's going to be very obvious that something has gone on in that family dynamic. I'm not saying it definitely would be behaviours, but something needs to be looked into further. And again, as practitioners, if you get a case like that at an early stage, the earlier you can identify this, the far better it's going to be. 1, for the courts, 2, for your client, and thirdly, for the child, of if this is happening, putting a stop to it very quickly. Now, again, I've given you 2 images there that give a very clear-cut example of this. I caveat this, these aren't my images, these are taken from Parental Alienation UK's website. The way they present it is exactly that, but these were 2 individual pictures drawn by a child a few months apart. Other information presented as the lawyer with me is sceptical then as to why the outcome was the outcome, because the court found in that situation there wasn't alienating behaviours. But this sort of nicely leads me on to questioning why then a child might be presenting with the behaviours they're exhibiting, and why, you know, when one parent says it's alienating, the other parent might say it's certainly not. I'll put in there, and I'm not going to rehearse it at all, the case of YRes, Parental Alienation cult. As the name suggests, this is quite an extreme version of alienating behaviours. But I think what's important to take from this is on the face of it, the case presented by the mother was she was simply pursuing her rules of her belief, her views as to what she felt was the right way to raise her child. In the midst of all of this, she's actually following a genuine certified cult, and that cult requires the cutout of the other parent. That was very clearly parental alienation, and that's exactly what the court said. Now, the court did also say that where you've got such a clear-cut action as that, the party who is displaying those alienating behaviours needs to really come to court with a genuine commitment to extricate themselves from that culture and that approach. So again, I give that because these are some really nice, really clear-cut examples of what we can see as alienating behaviours as what they may be. But the day-to-day cases that we might identify, as I said earlier, are likely to be far more subtle. They are likely to be far more spread out across a period of time. It's likely to be if one child's attitude has changed or certainly significantly diverged from if there's other children in the family as well. And you've really got to question, and that's why I say really question why that is happening. If you have those examples I've just run through where they're really clear cut, great, fantastic. I think you've got the case to run an alienating behaviours argument there and raise it at a very early stage and say to the court, this is what we're dealing with, so it can be appropriately allocated. But if you're getting information from your clients about, well, this child stopped talking to me, or we used to have a really loving relationship, probably, yeah, and you know, I would say on behalf of us at court, that's what we're there to do. There could be genuine other reasons for that. Could there be, you know, for example, that the child is presenting as saying not wanting to see the father because or mother, sorry, because there are other actions and other allegations going on behind the scenes where actually that child has a justifiable reason not to want to see that parent. Have they witnessed domestic abuse? Have they been a victim of domestic abuse themselves by, of course, the new legislation and their definition of the same? Those are the questions you need to consider. And I think as practitioners, again, at the early stage, if you ask yourself that question and you start to get to the stage of going, well, actually, does this sound reasonable? Does it sound justifiable? And I think that's all you can do at the early stages. It's almost a gut instinct. And you're landing on the side of, well, actually, no, it doesn't. That's where you should be advising clients that potentially you have a situation of alienating behaviours. What I would add, and I haven't included it for this, but what I would say is CAFCAS have an incredible resource available to them on their website, which is a alienating behaviours thinking tool. Now, this is a practical tool for practitioners, and it's very much an analytical tool to be used after practitioners have completed their interview with their parents, after they've obtained a range of other information, and after they potentially, if it's available, got information from the police, from schools, from the local authority. And again, I say it's really useful. I've had a play on it myself, and it really is sort of a drop-down criteria of how extreme would you say this sort of behaviour is, and at the end it sort of gives you a mathematical equation of whether or not there is a genuine consideration for alienating behaviours there. So I would fully recommend everybody has a look at that if you even think you potentially might have a case of alienating behaviours. I move on then to, well, how do we evidence this? After saying of this, after sort of saying in the nicest way, alienating behaviours or parental alienation can be very difficult to sort of pick out and scope as a day-to-day issue. What's the approach the court will take? Now, I've used the case of Region B. As I say, this is the most recent case that I found, literally published on the 30th of August. It fully supports the case of Re C, which was back in March this year. But fundamentally, it's finding that a finding of parental alienation is exactly that. It's a fact which the court has to deal with. It's not for experts, particularly to opine whether or not they believe alienating behaviours are there. Of course, there are some elements which fall into category, but ultimately it's for the court to decide whether or not they view, after seeing all the evidence, there are alienating behaviours or amounting to a finding of parental alienation. That, of course, is going to be informed. Now, the question one might ask then is, what sort of experts do we want? What sort of experts do we use? I'm going to park that and leave John to address that further with you. As I say, he's sort of going to talk about Re C and his interest, but I would fully support every practitioner here or any person involved in this talk reading the case of Re C as well, because it is, again, it's a very resourceful overview of where we've got to today with alienating behaviours and where we might be heading in terms of the use of experts to prove such cases. Fundamentally, though, it's just like any other allegation of abuse. It's likely to need a fact-find hearing. It's going to have to be a very holistic approach. Narrative statements are likely to be the way forward, and in fact, the most recent guidance says that's the most likely thing the court are going to have to start thinking about very early on. The burden of proof is still exactly the same as it would be in any other sort of allegation of abuse as well. As I say here, I'm not going to recite here, I've sort of gone over that. It's the balance of that evidence is likely to come down to our client's credibility or your client's credibility, their attitude to the other parent. I'm sure we've all had cases where we sat with our clients and we start talking to them and maybe in the nicest way, talk the good talk to begin with, but when you start digging down into why their reasons for certain things are, for example, contact, those snippets of, well, I just don't want them to spend that much time with my child and their own use of terminology, I think is something, again, as practitioners, not to overly start being critical of our clients, but to stay alert to of, well, is the other side potentially going to be able to twist this further down the line? The other thing, of course, is within these sorts of cases, one can always expect that a guardian is going to be appointed. It falls within the practice directions for the same, and again, I've got it there for you. The complexities of these sorts of cases are ultimately going to require the child to be separately represented. Again, the draft guidance fully endorses that and fully recognises this will be the position. And sort of if that guidance comes to set fruition of this is what the judges are going to be thinking about when you have the first hearing and first case management of any case where alienating behaviours alleged or even potentially could be alleged. Now, to help, as I say, this draft guidance is still in draft format, but again, I would fully support everybody here having a good read of this draft guidance. It is, I think, a good 20 odd pages long. But it really does pull the history of alienating behaviours and parental alienation together and run through various scenarios and topics. Now, from it, these three criteria here is what the court are expected to have in mind. This is almost going to be their checklist for alienating behaviours. Is the child refusing, resistant, or reluctant to engage in a relationship with a parent or carer? Is that refusal based on the consequent actions of the non-resident parent? Again, using non-resident because typically the resident parent is the one displaying these attitudes. And again, has the resident parent directly or indirectly impacted on the child through their behaviours? I go back to those examples that I gave earlier, and I go back to my reasoning for potentially including silence within this. It's the indirectly impact on the child as well. If a child starts talking about their non-resident parent and they really love and they're met with a wall of silence because the attitude is, that's fine, it's all well and good, you can see your other parent, I just don't want to hear or speak about it. And that starts to cause this negativity. That's where you are going to have a client that you're going to see a parent drifting into alienating behaviours. And of course, if it ends up in the courtroom, we are talking about serious effects to that as well. Pulling out from this draft guidance, again, there is a lot in this. So all I have done is sort of pulled out what I would say are the highlights to this. I think very positively, and it's not a criticism, but I think very positively, given the complex nature of alienating behaviours in these sorts of cases, I akin it in my own brain to very much, cases of coercive control. They're more of a system rather than an individual situation most of the time. The guidance is very clear that if those elements are met from sort of the gatekeeping, it goes to a judge. It goes to either a district judge or it goes to a circuit judge. Magistrates are not to be touching alienating behaviour cases. And again, I say that for all of us to bear in mind in case we ever have a case and sit there and we go, oh, it's listed in front of magistrates, it really shouldn't be there. Hopefully, if this guidance becomes the approach, we can all turn up at a very early stage and go, with all due respect, your worships, not today, let's get it in front of a judge and deal with this appropriately. As I say, the courts will be seeking to actively and robustly manage these cases from a very early stage, which is why if you get these cases, it's going to be important to identify it and appropriately plead it to the court in either a witness statement or in either a position statement or again, narrative statements. If I know there's a lot of work at the minute going into the gatekeepers in trying to do a lot of early stages when applications are issued, to provide as much information to the court as necessary. Again, as I say there, I'm not going to run through all of these points, but Guardian's going to be appointed as well. That's one thing to always keep in mind. Of course, I believe everybody here is private practitioners, and it's often lost. I do a mix of public and private, and it was always in the back of my mind, but in public law, we always take for granted that pretty much everybody is legally aided. The costs of the Guardian, the cost of potentially any additional experts, they're all going to be expected to be paid by the parties. Again, I think John's going to cover this a bit more later on when we're talking about experts as well. But that is, again, something to really think about if, for example, you get a client coming to you saying, I Googled alienating behaviours, this is how I want to run my case. You as practitioners on the ground are going to really have those robust conversations about, well, if you want to do that, there's going to be a financial implication to this as well. I move on then to why we're talking about this. What's the point and what's the purpose of seeking a finding of parental alienation or seeking to pursue alienating behaviour allegations? Now, typically, what I've come across, we're normally looking at a change of residence issue where there's real issues where the child really doesn't want to engage with one parent because of the other parent's action. Your client will either be saying to the court, look, this needs to change, and the only way it can change is to remove the child from the environment. What is very clear in the new guidance is that's not going to be automatic. That is not if the parental alienation is found or alienating behaviours are found, it does not automatically follow suit. That is a reason to change residence. It's going to be a welfare consideration. It's going to be all the normal criteria that we expect to see whether or not it's in that child's best interest. As I say, I track back to that case of YRes, whether or not the alienating parent can really move away from their behaviours if they know they're doing them. if they knew they were inadvertently doing, what sort of work can they do? Do they want to do that? Are they showing real commitment? It doesn't necessarily follow suit that it will just be a complete change. Of course, that's not the only outcome your clients can see, but that's sort of, we're talking the top tier level there, and I'm sure everybody here is experienced enough to work down from there as to the best approach to present the case. If, you know, there's a real issue with contact, can family members step in? Is there going to be, you know, an alternative means of actually one parent really shouldn't be involved in contact arrangements, so on and so forth. Again, I've put in there as well, additional experts not always necessary. Going to leave John to talk about that. Feels like I'm firing off a lot on John, but there is quite an overlap here, which is why these three topics go quite well together in our view. And again, John will talk about the case of Receipt. The closing note that I really want to finish on, and I think I'm almost spot on for time as well, is the fact this guidance really is draft guidance. It's still in a consultation phase. I encourage everybody to have a read of it. Of course, there is an active seeking for sort of feedback on it. If you have a read of it and in your experience you think there's something different, get involved. That will probably be one of the best sort of recommendations for all of us here. This really is a developing area, and quite frankly an area which needs clarity. The best people who provide that are people who are on the ground, working with clients, seeing the sorts of behaviours that, in the nicest way, justices and judges and higher-ups may be 2-3 steps removed from it. It closes on the 16th of October, and I think that's the last thing I can add. I will very kindly now that I've mentioned him so often, hand over to John to address you further on experts within private property.
Thanks, Scott. Good evening, everybody. Just picking up where Scott left off, while he's setting up the tech for me very helpfully. The 3 limbs of establishing the alienating behaviour that Scott touched on, which do appear in the draft guidance, are actually lifted from the President's judgment in the case of Receipt, the 2023 parental alienation case that Scott was talking about. So if you're looking for your definition of what needs to be established for parental alienation without having to wait for the draft guidance, but also using a legal authority from the first President's 3 limbs within that case. So I'm doing a talk this evening. It's called A Brief Introduction to Applications for Expert Assessments in Private Law Proceedings. Hopefully a bit of fun with Part 25 applications. I know people might be smirking at the idea of Part 25 applications being fun. Often get a bit of a bad rep for being dry, but in my view, Part 25 applications with the expert assessments can add a sort of extra dimension in any case, which really helps the court understand the issues and identify the best outcome for the children, but also the family involved. I mean, what comes to mind when I say that is if you've got a client, for example, who is arguing that their partner's been really controlling, or vice versa. It might be an allegation that the partner's been manipulating children against them, what we'd call parental alienation. Having an expert reporting on that issue and the insights that the other party has to concerns once a factual matrix has been established can add a lot of depth to the case and really give you something to help guide your client through the process and ensure that the court's in the best place to make the welfare decisions that it needs to. So we'll have a look at applications for expert assessments in these proceedings. I've done quite a thorough handout, which you should have all received prior to the talk. So hopefully there's no need to take any notes as I go through it. I understand there's quite a wide range of legal experience amongst people who have joined the talk. So I've tried to cater for everybody. Hopefully there's something there for everyone. Even if there's a lot of this talk that you already know, hopefully buried in it, there'll be some useful information for you. So starting off with necessity, this will be a familiar topic to most of you, the legal test, of course, for expert assessment. Now, within this, you have the necessity test, and I have to say the solicitors are much better at this next bit in my experience, than us counsel. But the Section 13(7) criteria was on the Children and Families Act 2014. These are often left out in applications for expert assessment. I've even noticed counsel of a couple of decades experience not touching on this legal test at all when making their application in court. I know solicitors are generally very good at including them in their Part 25 applications. It's always helpful within the statement of support of any application to be referring to those Section 13(7) criteria, which really help the court to understand whether what you're asking for, whether the expert is necessary in order to resolve the case. And most importantly, I think, with private law proceedings is going to be, well, I've sort of summarised the Section 13 criteria myself, but that third bullet point that I've put is what other evidence is available, because of course it's likely that you'll be having a Section 7 welfare report, and so it's likely that CAFCAS or if NIAS are involved as the alternative 16(4) guardian, they might be able to report on some, if not all, of the issues in your case. And you need to think very carefully, obviously, about the remit of the application and why it is that you're asking for the particular expert that you've identified to complete that assessment. And the sorts of issues that we're talking about, I've grouped a couple of them here. Mental health issues. So here we're talking about psychiatrists. As a rule of thumb, not a very legal approach, but as a rule of thumb, I generally say if you've got a question about diagnosis in relation to mental health, or if there's a question about medication in relation to mental health, then psychiatrists might well be the expert that you need to approach. Behavioural and psychological issues. This is when you're looking at why somebody is behaving in the way that they are. Typical examples, in my experience, are those that I gave at the beginning. So controlling coercive behaviour, for example, where there's a lack of insight, a real lack of insight on the party against whom findings have been made in understanding their behaviour as being that way, then a psychologist can help unpick that and also make recommendations for work around that. And also, as we'll get on to a bit later, in respect to parental alienation, psychologist is likely going to be the expert that you want to approach in those cases. Drug and alcohol testing, most of us will be familiar with toxicology reports, and parenting capacity. Here, typically, because, as I say, you've usually got Section 7 report order, it's unlikely that you would need an ISW. But if there are particular cognitive needs that need to be taken into account, for example, the parent has a learning disability, then it might be that you need a specialist trained ISW to be able to conduct certain parts of that welfare report. And then I really highlight that last point where I have others, because really, when we're talking about expert assessment, we're talking about what's necessary to assist the court to resolve proceedings justly. There's no limit, really, to what you might need an expert to help out on. And one particular case that I have that comes to mind was a case I did. It was public law proceedings, but the argument was over a special guardianship order, so a private law order. And in that case, the real limiting factor for my client who was seeking the special guardianship order that everybody else, local authority, parents, guardian, ruled against, was physical health issues and whether she would be able to care for the children through their minority. And it was her respiratory health in particular that the professional parties were concerned about. And during cross-examination, it became very clear that this really was the central issue in the case. After cross-examining the social worker, I made the application, well, my solicitor, I should say, give fair credit, my solicitor made the application for the expert assessment, which of course I raised at court. The judge agreed that there was a gap and that there was a need for such an assessment. Off we went, had the assessment done. The respiratory expert came back and said, actually, it's not as bad as everybody had thought. Back when the social worker was completing their assessment, the result was that all the children went to stay with my client under the special guardianship order rather than long-term foster care, and some of the children would even have been adopted. So I know that's public law, but the principle, I think, still applies in the case of private law proceedings, that if there are question marks where you feel that an expert who has expertise beyond that of the Section 7 report order is needed, it is worth looking into. We'll touch on costs a bit later, because that's often the sticking point with private law proceedings. When should an application be made? Well, of course, we don't want to jump the gun. As Scott said in his talk on parental alienation, really what we're looking for is there needs to be an established factual matrix. So if there are disputed allegations, then you either need to have the separate fact-finding hearing in order to get to the bottom of whether the allegations are proven or not, so that the expert has a factual matrix from which to work. Or in some limited circumstances, although perhaps this isn't most appropriate in private law if you've got cross-application allegations, but in some limited circumstances you could have an expert report on an either-or basis. So whether the allegations are found to be proven or not, but that can often get quite sticky. So perhaps in private law in particular, more likely to be the former. And the timing of the application for your expert assessment and coming after the fact-finding hearing, if there are those disputed allegations, was brought into real sharp focus in the recent case law and the draft guidance that Scott has already spoken about. So on this slide, I've just got some extracts from that draft guidance. And in particular, I think that middle quote there, where the factual matrix surrounding a case of alleged alienation is one for the court alone, in the same way that the court must, at the first opportunity, gather evidence and list a fact-finding hearing where other forms of abuse are alleged. The court must gather the evidence and make findings in relation to alienating behaviour. So very clear in the draft guidance there that you need to have the factual matrix established first. And I put at the bottom of that slide, see Appendix 1, mapping the litigation journey where alienating behaviours are alleged. Now, what Appendix 1 is, you should have had it attached to my handout. It's actually, because I couldn't quite get the technology to work as I wanted, I couldn't cut out the flow chart, which goes through the right course of action for making expert applications in private law proceedings. So you've got the whole guidance that Scott was just talking about, I think. So it's on page 3, I believe, of that guidance. It's a really helpful flow chart which sets out the different stages and when you should be thinking about making that application. In fact, it's so helpful that Scott's also included it at the back of his handout, so you've got it twice. But I'd certainly recommend that you save that and can refer to it going forward. As I said at the beginning, again, draft guidance, yes, it's draft, and secondly, it's guidance, not law. So if you're looking for something more authoritative, more definitive, the President, in the case of Reed C from earlier this year, which Scott touched on a lot, and he did say that we'd be talking about it a lot, is that authority. I've put this in my appendices 2 and 3. So you've got both the Family Law Week case summary. I hope Family Law Week won't mind me using their case summary. They're a partner of Westgate Chambers, and I know there's some exciting news to be announced between the two of us coming up, but I can't say any more because my clerk, Stuart, will have my head if I do. But I've got that case summary in there for you if you're pressed for time. I've also attached the full judgment from Bailey, which I would highly recommend that everybody on this talk reads when they have some spare time, because it really unpicks not only parental alienation and how the courts are looking to approach it, but also approaching expert assessments in such cases. And it's also really what a lot of that draft guidance, which Scott has just talked you through, is premised on. So it's a really useful case to get to know. And again, we see there on the quote, which I've lifted from the case at paragraph 103, the need for the court to make the determination about the alienating behaviours rather than the expert. So don't make the application without a factual matrix. either the judge will give you short shrift if you do, or perhaps even worse, they may grant you permission, which will give you all kinds of difficulty going forward, especially if the other side's a litigant in person. Do have in mind from an early stage the type of expert assessment that you might be looking for further down the line. Now, as I say, typically when we're talking about parental alienation, it's likely to be a psychologist. It might even be a global psychologist who will be looking at the nature of the relationship between the child and the two parents. So bear that in mind. The idea is to look at what work will be required for the parent who's found to be exhibiting the harmful behaviours and how to address those behaviours which have been identified. Because Scott quite rightly says in his talk, it doesn't necessarily follow that if alienation has occurred, that there's going to be a change of residence. Similarly, in other cases, just because there's been domestic abuse, I don't mean to minimise that at all, but if there has been domestic abuse, it doesn't necessarily mean that there'll be no contact with the children at all. So these expert assessments, really the aim is to look at how can that harm be mitigated and what work is needed. And when thinking about that, again, you need to be thinking of the Section 13.7 criteria from the Children and Families Act 2014. Is this something that CAFCAS or even NIAS could report on as part of Section 7, or does it step outside their remit of expertise? And for us private law practitioners, I think of great assistance is having CAFCAS and or NIAS involved in the case, because they are likely to make recommendations when it's needed, particularly in cases where, as Scott's alluded to, they can make that recommendation for expert assessment. So yes, think about all the case management directions that you need to get to your expert instruction. Look at the end result and work backwards is my advice. So if you think you might need a psychologist to report if the findings that your client is seeking has been are made, how do you get there? If the client's case is based on allegations rather than an established factual matrix, then it's likely you'll need a fact find, and you'll need to think about all the consequential directions you need in terms of evidence to get to that fact find and make sure it's effective. Identifying the expert, well, thankfully, usually this is quite a straightforward exercise. If an expert is recognised by a professional body, then they will most likely be suitable to provide opinion evidence on their area of expertise. I think, for example, solicitors are regulated by the Solicitors Regulation Authority. Most experts are similarly regulated by their bodies, such as doctors. If in doubt, though, there is the case, which I put on the next slide, from Scotland, UK Supreme Court, but is adopted in the President's Memorandum of Experts in the Family Court, October 2021. And the two key principles from the Supreme Court case, really, I've set out there. Firstly, the expert must demonstrate to the court that he or she has the relevant knowledge and experience to give either opinion evidence or factual evidence which is not based exclusively on personal observation or sensation. And then the second bit is where there's more difficulty, where the science or body of knowledge is not widely recognised. The court will refuse to authorise or admit the evidence of an expert whose methodology is not based on any established body of knowledge. So when you're considering an application and trying to identify your expert, or the other side to identify an expert, this is where CVs, which I know can often just be glanced at, but CVs can make a big difference. And I've been involved in cases where the judge has looked at CV and has thought that the expert identified is not suitably qualified and refused it on that basis. And particularly in relation to psychologists, there are some who hold themselves out to be experts, but their expertise, the methodology is not based on the established body of knowledge. One that comes to mind is there was a psychologist in America, I can't remember their exact name, but they believed that autism could be treated, and they had and had been caused by the coronavirus, essentially. And I've had cases where that psychologist, or at least their essays or extracts of their work, has tried to be adduced, and the judge has said no, because that's not, the methodology is not based on an established body of knowledge. So keep an eye out for that. REC, again, this is looking at how this sort of issue is tackled in practice, because of course looking at guidance is one thing, but in practice REC tries to grapple with this a bit. We've got the first bullet point there, where the court, the President said the open house nature of the term psychologist is unhelpful and potentially confusing. And that's because there isn't a sort of strict regulatory body that that governs whether somebody can hold themselves out to be a psychologist or not. And this really touches on the point that I was just referring to about that psychologist in America with the autism. So it's not as straightforward as if you have a pediatrician or a pathologist who will be regulated by such a body. Psychologists aren't always so regulated. But as you'll see from the final sentence there, the High Court, probably quite rightly, thought it was a matter for the actual profession and Parliament about whether a tighter regime should be imposed, not the court. Second point there, that the CV needs to be clear. Setting out experts' qualifications and experience is probably quite self-explanatory. Bullet point 3 goes some way to assisting us identify psychologists who the court are more likely perhaps to approve than others, and that's the HCPC registration, which is the Health and Care Professionals Council. So that should be on the CV. And as you see there, the High Court said that should provide a reliable one-stop method of authentication. That said, in the final bullet point, you'll see there the President saying it's not for this court to prohibit the instruction of any unregulated psychologists. So just because they don't have that doesn't mean that the court won't approve them. But if the court does approve an unregulated psychologist, they should, as a course of sensible practice, as the President describes it, indicate in a short judgment why it's appropriate to instruct that expert. So again, something to look out for there in relation to psychologists, and particularly this was an issue in relation to looking at parental alienation, because as you'll see when you read C, there are psychologists who are holding themselves out to be experts on a particular topic of alienation, but not always when it was appropriate to do so. Conflicts of interest. I put this in just because it was an interesting point that I came across when I was looking at interim guidance, which came out in May last year. I'm hoping it's quite self-explanatory, so I won't spend long on it. But here, I think the key point is that the court should be very cautious when it's being asked to consider assessment and treatment packages who are offered by the same or linked provider. So this is when you get a sort of psychologist who makes recommendation for work that only they can provide. That's the sort of thing that comes to mind, because that would go against the Part 25 rules which are in place to try and stop there being a conflict of interest. The thing to watch out for here, of course, is be careful, because there is common practice for some service providers, and CAMS comes to mind, and you'll see that actually at the bottom of the page, where the organisation will complete the initial assessment by one practitioner, and then a second practitioner will deliver the intervention. And I know East Sussex, in public law, those who do public law proceedings would be familiar with SWIFT. So that's a similar set up there. But in terms of private law, that's certainly something to look out for. If you're getting recommendations that only that psychologist can provide, then that probably would go against Part 25 rules in relation to conflicts of interest. How to avoid those? Well, the main thing is that we've got rules in place really from the practice directions, which hopefully will put an end to this. And it's really just making very clear that some of those documents, which perhaps I'm not saying that anybody here does, but that perhaps just get a quick glance, maybe do require a bit more attention. For example, the letter of instruction. make sure it's very clear that all of the issues that the expert's being asked to report on, and also the need for the independence and integrity of the assessment, is all detailed there. It should be, because it's within the Part 25 already, but make sure it is in there. And also, when you get that further recommended work, the court should be mindful any programme of work proposed by an expert that raises a professional conflict is contrary to best practice and challenges the integrity of any updating expert instructions. So keep an eye out for those points. Costs, and this I think is probably the main point that I wanted to talk to everybody about, and I hope I've got a little bit of time to do so. With any expert's report in private law proceedings, costs are usually significant. This is especially the case when you have a psychologist or a psychiatrist on board. Certainly going to be the case with an ISW as well. I'd even go so far as to say they're likely to be significant with toxicology testing, particularly in relation to some clients. I know that often toxicology assessments, reports can be £300, £400, £500, which might, in the context of legal proceedings, not seem like a lot, but some litigants in person, it can be really significant outlay. And also, it's worth bearing in mind that the cost can be far higher than that. So there needs to be thought about costs and how any expert assessment is going to be funded. Now, if both parties are legally aided and the experts agree to report within those legal aid rates, then the issue should be straightforward. But issues might arise when, in those three examples that I put there, it's just by way of my own experience. Firstly, the rates for the experts are in excess of codified rates. Now, this doesn't tend to be so likely when it's a psychologist or psychiatrist, in my experience. It tends to be more with an ISW who don't see, and it's very difficult to find an ISW, particularly those who are PAMS trained or parent assessed trained, to be looking at parents with cognitive difficulties who work within the legal aid rates. The second one is experts not listed in the remuneration regulations. This goes back, my anecdote of the respiratory expert would be one of those. So it's likely you'd need an application for prior authority if you were to instruct such an expert. And then the third one, I think, is one that we probably all come across fairly regularly, is one or more of the parties a litigant in person, because this can throw a real difficulty in the case. Firstly, of course, a litigant in person is unlikely to make an application themselves. Secondly, agreeing a letter of instruction with a litigant in person might prove problematic. And thirdly, of course, funding. And some experts, certainly in my experience, won't work with somebody who is a litigant in person because of the funding, because they don't have that guarantee that their fees will be paid when they become due. And that puts pressure on the solicitors, as I'm sure most of you know, because of course the solicitor doesn't want to be left out of pocket if the litigant in person themselves doesn't pay and the expert comes along and says, well, look, you've instructed me, so I need all of my fee paid. So end up with a bit of a chicken and egg scenario. So how do we get around that? Well, I've put some ideas down. Hopefully there are some new ideas that not everybody would have heard of. I apologise if you are aware of all of them already. First one, in terms of toxicology testing, GPs, some GPs will do toxicology testing, so a litigant person could go to their general practitioner and ask for hair strand testing in terms of toxicology. Secondly, appointing a 16.4 guardian. In many of the cases that we're talking about, where an expert is identified as necessary, it's likely to be so complex that a 16.4 guardian could be appointed and that there are grounds to appoint them. Now, two useful notes on this. Firstly, you get the recommendations about when an expert would be necessary. And secondly, of course, a 16.4 guardian would be legally aided. And so there is that public funding certificate should neither of the other parties have it. In those scenarios, then of course you bring the case into the realms of prior authority. So the 16.4 guardian solicitor would have to make that application. That would have to be timetabled into the case management, and also the court might want to think about assessing the parties' means and possibly declaring either or any of the parties impecunious, so that when the legal aid agency is approached on the basis that there's an unequal apportionment of costs, it's more likely that that application for prior authority will succeed and therefore keep the case on track. And if you do go down that route, as I'm sure many of you are aware, it'll be important to recite that on the face of the order so that can be provided to the legal aid agency. Final one is funds held on account. And this comes from a colleague in Chambers who conducted a private law case fairly recently, where litigants in person for the parents were the parents, and there was a 16.4 guardian. Question about who was going to fund the expert assessment. I think in that case, if I'm right, I'm sorry if I've got this wrong if they're listening, of the father, and the expert wouldn't even start the assessment on the basis that the father was a litigant in person. So how do you get around that? The idea was that the father would pay funds into the 16.4 guardian solicitor's account. I mean, it'd be a separate account, obviously. And on that basis, once the funds had been moved into the account and the expert had received confirmation of the same from the 16.4 solicitor, 16.4 guardian solicitor, then the expert was willing to commence the assessment. So that might be a creative way around difficulty costs when there's a litigant in person. A couple of caveats. If you're counsel listening to this, I would suggest you definitely check that proposal with your instructing solicitor before you go ahead. And if you're a solicitor, I would check probably with a managing partner just to make sure that that's something that your firm would be able to do. I hope at least some of that's been helpful to those of you listening. Thank you very much for listening. I know if there's any questions there, I think there's been told questions held to the end, and I'll hand you back to Scott. Things for a very brief update on public law.
Yes, I can imagine. I'm very grateful for you all staying with us. It's of course getting late. I'm going to fly through the next talk for you. I'm going to very much streamline it just to share some highlights, really, to assist those who don't do public law. As to where there's likely to be the overlap with private law. Again, this is being a focus on children proceedings and private children proceedings. Of course, there's likely to be overlaps in other areas as well, but sticking with the focus of obviously what we've been looking into today. I've sort of picked out what I see as the real highlights. This has gone horribly wrong in terms of formatting, but this there is a table I've created of, again, really simplistic public-private law sort of statutes that you'll see. Obviously, Children Act being very clear overlap between the two, and then the types of cases and the types of orders that you can get in public and private law situations. I think what I would aim to do for you in a very whistle-stop way is sort of pick out the real distinctions between the two. I'm going to give everybody the default. I appreciate everybody here is predominantly private law practitioners, so again, apologies if I'm taking you to suck eggs and you know this, but obviously the definition of public law proceedings is it's exactly that. The local authority are getting involved for the intervention on welfare of the child or children, and this is where they are taking the view that the child is likely to, or is that suffering significant harm. Don't. That's as far as I'm going to go with that, because we don't need to be here sort of any longer than you. I appreciate everybody's busy. Now, as I say, when we talk about public law threshold, private practitioners, you probably won't be used to hearing this. You might have heard it going around. It's not something to be afraid of. All it simply is exactly as definition. It's the legal level at which the court can make orders. As I've touched upon there, for a final order in public law, the court has to be satisfied that there is significant harm or likely that there is significant harm to be suffered, and that is down to the care the child is receiving through their parents and or the child beyond parental control. Those are quite rare, I would say. It's fair to say as a public law practitioner that we see in cases where children are beyond the parental control. I have to say I've seen one in one time, and I didn't necessarily agree it was appropriately the right legal approach. But that's a different story. If you catch me at a public event, I might tell you sometime. For an interim order, because this is the crux of it as well. Obviously, public law proceedings aren't one hearing and done very much like private law proceedings. There is a slightly lower reasonable grounds for believing there's going to be significant harm. Now, again, I haven't gone into it and I don't propose to go into it, but depending on what the local authority is seeking, there are then further legal tests. For example, the test of separation from a parent is different to just the threshold test. But this is the starting point in which the courts need to be satisfied that they can even start making public law orders. So that's key different one. You see, private law, you don't have that. It comes down to welfare, it comes down to what the court needs, and of course, there's still the consideration for a no order principle. What I highlight is the public law outline process. So in public law, it's exactly that. There is a defined process that the local authority should, and I may stress should, go through before seeking to issue proceedings. There is a real strive to get back to this because, again, there's time constraints within public law. All public law cases should be resolved within 26 weeks. So the more work the local authority does in the pre-proceeding stage of the public law outline, and the more prepared they come to a first hearing in court, should allow everybody to understand where they stand and sort of timetable moving forward. As I say, that is the effective differences beyond the fact that there are more parties automatically involved in public law proceedings. I think for private law practitioners, the thing to really focus on is it's still the welfare of a child. It's still the paramountcy principle of the children is the centre of all decisions. To sort of address things moving forward. I put in here, obviously, why I say all of this is relevant. Now, of course, the overlap with private law practitioners that you may see is there may have been previous public law involvement or previous public law proceedings. There even might still be ongoing local authority involvement. Either you have a child who's on a child in need plan or a child protection plan, but it simply hasn't got to the action before meeting stage or even issuing proceedings. And your client has decided, well, they're fed up of whatever the local authority are doing. They're fed up of waiting around for their contact to change. They want to issue their own contact application. If you have the local authority involved, the reason why I say all of this is it's sometimes very positive, depending on your client's position, of course, because it's effectively more information for you to have right from the get-go. Of course, we will all be aware that CAFCAS get involved at a very early stage in private law proceedings. They do their safeguarding letter. However, if the local authority are known to be involved, but very recently involved, it is likely CAFCAS are going to highlight that in their safeguarding letter, and any potential forward report, they're going to say, you're better off getting from the local authority because they, in short, money, some money's away, no more than we do. That can be a real positive. There can be a real history there and a real plethora of information the local authority bring with them. So I would say don't be afraid of it. If you know your client mentions the local authority of being involved, ask those questions. To what extent have they been involved? Are they still involved? If they are still involved, start thinking at a very early stage of what information can we get from the local authority, and or should we be inviting them along very early on to get involved in replacement, effectively, of CAFCAS. As I say, I'm flying through this because I want to try to highlight some of the other elements for you within private law proceedings where public law are going to overlap. Section 37 of the Children Act. This is a very positive one in my view. And I've had experience of cases with this. In fact, I had one, ironically enough, where there was the issues of alienating behaviour. My client had 2 orders of contact that the resident parent simply wasn't following. The child was then saying, I don't want any contact. I was there representing that, saying something is very, very wrong with it. And getting to the point of saying, well, we need a 16.4 guardian involved, we got that. Getting to the point of saying we also then want, a full investigation by CAFCAS as to what's going on. What subsequently happened is, because there had been previous public law proceedings, the local authority actually turned up to one of our case management hearings and asked to be appointed to undertake this investigation under Section 37. Now, what I would say is that is extremely rare that a local authority will turn up and ask to get involved in private law proceedings. What this is, though, is it's a weapon where if you feel on behalf of your client, or your client feels there are real significant welfare concerns that may reach the threshold criteria, you start saying to the judge, well, actually, you need to consider this, and you need to consider telling the local authority they need to investigate far more, and they need to follow their duties to investigate far more. Why? The reason I say this is because under Section 37, it's far more of a proactive and positive obligation than simply have a look into this, and if you say it doesn't meet the threshold criteria, fine, I believe that. The local authority are required to justify why they say public law orders aren't required or public law involvement isn't required. But they're also under the obligation to say there are other resources that they feel they have available to assist this family in any event, even if they don't think public orders should be sought. And that comes under scrutiny from the judge. Again, it's typically ill. Under statutory requirements, it should be quicker than a CAFCAS Section 7 report. It's required to be done within 8 weeks. But as I say, that isn't something where you can go in the alternative, let's get the local authority. It's only if there is that possibility that there are welfare concerns that might reach that threshold criteria. So it's something to be aware of. Again, the other real difference that I've pulled out is Section 98 of the Children's Act. Within public law proceedings, there is this, I call it, an anti-self-incrimination requirement. It requires the parents to actively provide as much honest and open information to the court as possible. They're not allowed to say, I'm not going to tell you that, judge, because I might incriminate myself and there might be criminal proceedings that follow. In public law, that's not a reason. The judge will say, well, there's protections in place. Again, there's maybe a jurisprudence argument over then to what extent that protection remains in effect if there's ongoing criminal investigations and potentially they perjure themselves. But I'm not going to go into that now. What I would say is this doesn't apply to Section 8 proceedings. So actually your client could very well turn around within private law proceedings and say, although I've been asked that question, I'm not prepared to tell the court anything about it because I think there might be some criminal liability there. Of course, if your client says that to you, that should probably trigger some alarms. But it's important to know in the sense of if there has been previous public law involvement and your client tells you about that and say you're for the non-fault parent, as I'm going to use the term, and they say, well, when we were in public law proceedings, he fully admitted to slapping my child and therefore I don't think it's right that we now continue with that previous public law order, or there's been further issues and I want the contact orders changed, so on and so forth. Hopefully the public law has done its job with the final order, but you never know, these circumstances arise. And we see, I think it's fair to say all the time as practitioners, it's always in the back of our mind, public law cases of, this is all well and good now, but what if this doesn't last? These parents may very well end up in private law proceedings. The reason I say this is because they may disclose information to you, which fundamentally you may not be able to rely upon without some sort of further advice, further permission from the public law courts to release that within the private law proceedings. And John quite rightly mentioned it as we were discussing how to cover these topics. Issues of disclosure arise there as well. If you're provided with information, where does that information come from is what I would say. John, I don't know if you've got anything that you might want to add on our sort of public law, private law overlap quickly at all?
Just one practical point that I thought about where you're talking about local authority intervention, and when CAFCAS might say leave it to the local authority to complete the Section 7 report. I mean, I'm sorry if everybody knows this already, but one thing that I found more recently is I had a case where it was fairly standard in my experience. You go to court, local authority are asked to attend. They said, no, we're not going to do the Section 7 report. CAFCAS say, well, they should do the Section 7 report because they've been involved with the family. And what we got down to was essentially, unless there's what's called a child in need plan or child protection plan in place with the local authority, you're not going to have, or it's unlikely that you'll have an allocated social worker to that family, so you won't have that history working with the family, and therefore the local authority are likely to turn around and say it should still be CAFCAS, even though we've had involvement with this family at perhaps, if we think about it, tiers of involvement at a lower tier, thinking sort of child and family assessment, it would be a child and family worker who's not a social worker and can't do a welfare report. Whereas if you get up to a higher tier, such as child in need plan, child protection plan, and then of course you get onto public law proceedings, then there'll be an allocated social worker, and then it'd be much easier to say it should be the local authority to do Section 7 rather than CAFCAS.
Well, thank you. That's helpful. Yes, I mean, I certainly should have clarified that in terms of you definitely want to be looking at what level of involvement the local authority have had, how recently, are they really going to be any extra benefit? Because I think, yes, it's right to say I've also had cases where you turn up and CAFCAS go, well, I'm going to leave this to the local authority. Local authority are rewarded then by the judge because they're not represented to crack on with it. 7 days later, they turn around and go, no, we don't want to do this. Here's our application to vary, and then you're stuck between a rock and a hard place. If your clients think the answer is you don't care, you just want these answers to move it forward. So yes, when we're talking about local authority involvement, it's only appropriate the local authority take over if there is a real heavy involvement, I will use the term as well. Apologies that's been a very whistle-stop side of things, but I don't want to keep people here too late. I think it's only right that we invite questions. If anybody's got anything, if you want to turn your mics on, or I know Stuart's been monitoring the chat as to who has a question or who's got a pressing need to ask us something.
It does look like we've got a few messages in the chat. I don't know if you can click on it and
Let's have a look.
Let's have a look. It could be questions, they could be people saying they're leaving.
Running away from us.
Okay, so first question from Holly. What might happen re progression of contact in circumstances where an NRP impacts the child's behaviour towards an RP through alienating behaviours?
Very good question.
Some good acronyms in there as well.
Yeah. Well, I'm taking NRP, non-represented party. That's how I'm reading that.
Or not non-resident parent.
Oh, non-resident parent. There we go. My apologies. Even worse. You can tell I'm getting tired as well.
Your own definition.
Oh, I think that's even more embarrassing now. Cheers for that, John. Impacts the child's behaviour. Well, so it's fundamentally exactly the same. Sorry, I should have really alluded to that. Is if it's the non-resident parent impacting the child's behaviour towards the resident parent, principally the case isn't any different. Beyond what impact is that having and what can be done to fix it. If it is a matter of actually that non-resident parent's actions are causing the resident parent hell fundamentally, because the child is acting up whenever they're staying there. I suppose the question then comes down to, well, what's the contact that non-resident parent should be having? Should there be a break in contact whilst this child potentially goes through therapy or treatment? If the court finds that actually there is a narrative there that this child has been told, for example, that simply isn't right, and that narrative has come from the non-resident parent, I would again akin it to fundamentally abuse situations. Is if that abuse has existed, is the contact the right level of contact for that parent? I don't think it fundamentally changes the approach. It's simply the outcome and what your overall goals are.
And it might be useful thinking about expert introduction. This might be something that a psychologist could help understand what impacts there have been on the child through by the resident parent, and how best to approach. I mean, if there hasn't been contact for a while, for example, how best to approach that sort of reintroduction in the least harmful way possible.
I think Aisha even helped us out there, but further down, she managed to so there we go. That's wonderful. As I say, for those remaining, if there are any questions, feel free to jump on the mics now. I'm sure John and I will welcome any emails if there are any. And yes, I believe the only other question or the only other comment was, of course, that the full handout will be sent around as well. So
shall we leave it there? And you please feel free to email Polly or I as well, if you don't feel comfortable emailing these guys directly. But thank you very much to John and Scott for 3 really insightful talks. And if you do have any questions about YRes, East or West Sussex, please do let Polly and I know.
thanks very much.
Enjoy your evenings. Thank you very much for having me.